So shall we start?
Yes, madam, I'm ready.
Okay. Good afternoon, everyone. I welcome you all to the webinar on the topic Important Supreme Court Judgments. Today we have with us SIVA PRASAD Pulva sir as faculty. Let me briefly introduce sir. Sir is qualified professional in cost accountancy, CS, finance, commerce, insurance and banking. He is having experience of more than 36 years in banking, financial services with cross-cultural experience and good knowledge in insurance sector. He has handled senior level responsible positions with higher level interactions and exposures. He has authored for number of books for professional institutes like ICSI, ICAI, ICMAI, IGNU, Insurance Institute of India, etc. Now I request sir to start the session.
Okay, thank you very much, madam. My PPT is visual, madam,
Yes, sir.
and my voice is audible, and the
Yes,
PPT
sir,
is
it is
yes and
audible.
correct. Okay. So, thank you very much, madam. And first of all, I wish you all the best to the insolvency professional for the financial year 24-25. And today, I will discuss about the two important cases, that is the judicial pronouncements of Supreme Court of India. But these cases are known to everybody. But the points are to be discussed. What are the points that is taken into consideration by the Honorable Supreme Court of India while giving the judgment? And these cases particularly related to real estate sector. Today, the real estate sector is booming. At the same time, the home buyers, the home allottees, particularly the flats allottees or independent houses allottees, are facing a lot of problems with the real estate promoters. And some of them are delayed the projects. Some of them are in midway, it will stop. Some of them are, even though they are taking the advance upfront, and they are not constructing the houses as per the contract or original sale agreement given to the home loan borrowers or allottees. So this is a perennial problem in India. Even though RERA Act is there, still the problems are there. RERA Act is there, but the RERA Act is the state. Some of the states they have implemented in full-fledged manner, and some of the states are some problems are there, challenges are there in implementing the particular RERA Act. But being a banker, I know how many people are suffering on account of non-allotment or not given the home, the dream home of the borrowers. There, particularly the construction period is 2 years or 3 years, whatever the schedule they have given. But most of the particular real estates they are not giving in time, and the quality is also deteriorating, and hidden charges are also more. And all these things are taken into consideration by the Honorable Supreme Court, and now the home loan buyers are also the part of the committee of creditors. For that, I'm taking the two important judicial pronouncements that was given earlier. And what is the crux of the problem? How they are visualized while giving the judgment, all these things I will discuss in detail. The problems and issues. The majority of the home loan buyers in India hand to hand struggle with after booking an apartment. Because I have also handled one case, particularly the real estate. Today, the apartments are the stoppage of the construction. Even though it is a going concern, But that type of skills are also required to the insolvency profession to handle that project. And going concern means the construction to be continued. That type of issues are chala. So many things are there. The sequence of events is dull, predictable, and overwhelming majority of the projects. And builders change prospective buyers before the homes are booked. The marketing officials are there in the housing projects. They are chasing the buyers and they are taking the loans. Even banks are also giving loans left and right, based on their income, based on their particularly salary or the income. And after that, the banks are giving that is taken by the particular project promoters and diversion of funds are there. Actually, today, the projects are constructed with the help of the funds given as an advance by the home buyers. The land is developer. The land is also not the owner of the project promoter. Promoter is not the landowner. He is taking the land from the other people and developing that particular land and constructing the buildings. And one side, the home buyers are giving the advance. The land belongs to others also. And he is a mediator. He is a mediator. But still, some of the banks, they are giving working capital loans for the shortfall amount, whatever it is. Normally, in my perception thinking, the project promoters, particularly real estate project promoters, they don't require any additional funds. The funds are even 20th floor or 30th floor, construction to be happened after 1 or 2 years. In the meantime, they are taking the advance, either 30% or 40% or 50%. Once that floor is reached, then he will ask the installments. And whatever the funds are taken as an advance, that funds are sufficient to complete the project. But in the meantime, most of the real estate promoters, they are a diversion of funds for other activity and misappropriation, mismanagement, and some of the project, particularly the promoters, they don't have the knowledge, they don't have the skills to complete the project in time. Even though manager project control techniques are there, like the PET or CPM, program evaluation review technique and critical path. And most of the projects are delayed 1 or 2 years. In Hyderabad, where I am living now, one project, after the deadline is over, after the 6 months only, the project was handed over to the promoter, the home buyers. The promoter, he diverted the diversion of funds to the political party as a donation. Thereby, the liquidity crunch, liquidity problem, they struggle a lot. In the meantime, whatever the 1,000 or 2,000 home buyers who are taken a loan from the banks, that loans are also turned into bad, non-performing assets. The buyers change the builder after the homes are booked. First, the builders are chasing the buyers. After that, the buyers are chasing the builders. This is a reverse trend. And the buyer's expectations of being low to point that the project is delayed by a year is considerable, wholly acceptable. And the poor construction quality and the deficiency is promised, even it is almost a first world problem. The true challenges emerge, the project stretched or stalled, the builder stops communicating. And once the liquidity problem and the diversion of funds are there by the builder, then automatically the communication links are cut from the home buyers. And the builders are strong. And one of the pushback against the builder viewed as irritants, unwillingness to understand the complexities associated with the real estate project. A legal battle follows the betrayed home buyers. Often leaves the developer's legal team is bigger than the construction team. The developer's legal team is bigger than the buyer's team. All these things ought to be taken into consideration while dealing with the projects, particularly the CARP process of the real estate sector. This is a special sector, and lot of challenges are there, lot of problems are there, and once it is midway stopped, the account turn into bad, and the home buyers or the financial creditor or the operational creditor, if at all filed, then it is a big challenge to the insolvency professionals. So that's why I wish to discuss about two cases, that is Chitra Sharma versus Union of India and Pioneer Urban Land and Infrastructure Limited and Union of India and others. These are two. Up to 5 o'clock I will discuss. About 3:30 we will break for 10 minutes. And what is the crux of the problem, particularly the issue in this particular cases, how the Honorable Supreme Court visualized the problem in a different manner, and how they are justify the home buyers. All these things I will discuss in detail. Chitra Sharma versus Union of India. That is the case number one. The background. What is the background of that particular case? The Insolvency and Bankruptcy Code, comprehensive bankruptcy law with a specific legislative intents. And still it is evolving. The evolving of the IBC based on the judicial pronouncements only. Even though 256 sections are there, still on account of evolving of that, and they are adding some sections, and whatever the regulations are there, that is also suitably amended based on the judicial pronouncement only, because the law is evolving stage. Even though it is started in 2016, really it was started after pandemic COVID only. That is 2021. And the amendments are brought out by the ordinance promulgate in June 2018 brought the home buyers within the purview of the financial creditors. Everybody knows about this. In 2008 only, 18 only, the home buyers are brought under the fold of the Committee of Creditors, Financial Creditors and IBC, and hence necessarily they are the part of the COC. They are part of the COC now. And once it is a good sign, it is a good initiative. Why? Because they are also contributing. They are also contributing a lot for the project, particularly the real estate project. Once they have not given the advance, once they have not purchased that flats, which are going to be delivered by the promoter after 3 or 4 years, and he is taking as an upfront, and with the help of the home buyers funds only, the project is constructed. The land also, most of the cases, the land is also not belongs to the promoter. And some the agriculturist, they are giving that land and converted into commercial land, and they are giving, and they particularly the promoters are also allotting some flats to that particular the land owners. So here, this is a good sign. Why? Because they are also contributing. Operational creditor, they are supplying the raw material or whatever the services are there. But a financial creditor, they are giving the funds and interest also. But at the same time, the home buyers are also providing money. And if at all it is not given in time, as per the sale agreement, they will tell that we will give interest of so and so or monthly probable rent. In the all these things are built into the sale agreement also. And today, some of the states, at the time of allotting the flat, they are doing the registration. And some of the states, after completion of the flat, and they are registering with the register office, the register office. Different practices are following by the different people. This case, particularly envisages CARP, is initiated under the procedure of initiating a new resolution plan. Actually, whatever the existing resolution plan submitted and rejected by the COC and the Honorable Supreme Court of India, from the scratch onwards, you start the process. The eligibility criteria of the bidders and the process of asset disposal in the light of protecting the interest of the home buyers. That is very much required. Further discussed in the present case. Because of the process of asset disposal, once the liquidation is there, these people, whether they have to be treated as a secured or unsecured, because they are contributing for construction of the building, but if at all they are treated as unsecured, then in the order of mechanism, they will come later on after paying the amount to the financial creditor. Not only that one, the facts of the case, particularly I will discuss about the facts of the case. Article 32 of the Constitution of India rights to the constitutional remedies. It is a fundamental right which states the individual have the right to approach the Supreme Court. That's the home buyers are approach. Because justice is not there for them. Even though they are spending a lot of amount for their dream home, the home is not they delivered on that particular due date. And with the help of the home buyers funds only, the builder is constructed. And seeking the enforcement of other fundamental rights recognized in the Constitution. The proceedings have been initiated under Article 32 of the Constitution, protecting the interest of the home buyers. The floated project floated by JP Infotech Limited, that is JIL, J-I-L, JIL. So, to protecting the home buyers, that is required also. Okay, financial creditor are providing funds, they are charging interest. But these people, they are providing funds for construction of the houses. But these people are deprived in most of the cases. So that's why after a lot of discussions are happened, and finally the verdict was given by the Honorable Supreme Court of India. In JIL is a special purpose vehicle created by holding company. It is a subsidiary company of the holding company. Holding company is JAL, J Prakasha Associated Limited. JIL is a special purpose. In suppose take for example, in real estate, the main holding company, subsidiary company, n number of companies are there. One is for maintenance, one is for painting, one is for construction. So many, they are creating so many subsidiaries. And being an IPS, we have to understand the chain of the subsidiaries for the holding company, how the funds are moving and what for the activity. Recently, I also handled one real estate. In the real estate also, 6 subsidiary companies are there. One is for maintenance, one is for construction, and one is for paints and all these things. Different subsidiaries are also floated by the holding company. And this is this special purpose vehicle, that is a JIL, for the Yamuna Express agreement, which finance was obtained by the consortium banks. The JIL was financed by consortium bank, more than one bank. That is IDBA Bank is a lead bank. The consortium leader is IDBA. So, the special purpose SPV is a JIL and floated by JAL, that is a Jayaprakash Associated Limited. And the particularly this is the purpose is Yamuna Express agreement, for which was financed by the consortium leader, that is IDBA Bank and others. But IDBA Bank is the consortium leader. Against the partial mortgage of lands acquired in the Noida, Agra sector and pledged 51% of the shareholdings of the job. Actually, for this loan, particularly the JIL loan, financed by consortium members, and the consortium leader is IDBA. And for that loan, they have given some land as a collateral security. And 51% of the shareholdings of JAL is also pledged to the bank for getting the loan for JIL. That is subsidiary. The housing plan was envisaged for construction of real estate project in two locations land acquired. The housing plan was envisaged and the construction of real estate projects. And the two locations they have identified and the land is also acquired. IDBA Bank has initiated a petition against the JIL before NCLT seeking the initiation of the cooperative solvency. Because they are defaulted, the account turned into non-performing asset. That's why the IDBA filed an application under Section 7 of the IBC Code with the NCLT, Allahabad. A default of 526.11 crores in repayment of dues by JIL claimed by IDBA Bank. Even only one bank, IDBA Bank, the total amount is 526.11 crores by the JIL. That is only the share of the IDBA Bank, even though IDBA Bank is the consortium leader. NCLT initiated the CIRP. And in respect of JIL, that is a subsidiary company of JAL, J. Prakash Associates Limited, an order of a moratorium were issued under Section 40. This is a normal course. The interim resolution was appointed and the submission of claims by the creditor called for process the event management. I am talking about the CIRP is nothing but a event management. The events are there, the sequence is there. So public announcement or calling the claims or the appointment of a transactional auditor or expression of interest, whatever it is there, all are called events. And that's why at the end of the resolution, CIRP regulation issued by the Insolvency and Bankruptcy Board of India, they have mentioned that they have given the time schedule T+1, T+2, T+16, T+4, all these things. That's why I called it as a event manager. Once that event is over, Form H is submitted, then the event will be closed and admitted or approved by the adjudicating authority. The interim resolution was appointed and the submission of the claims by the creditor was called for. Okay. On 16th August 2017, Regulation 9 was inserted. Before that, Regulation 9 is a 9A was inserted to include the claims by other creditors, and the press note was released by IBBA clarifying home buyers could fill in Form F as they could not be treated at par with the financial creditor and operational creditor earlier. So that's why on particularly 16th August, they have issued the guidelines and inserted the regulation 9A. The home buyers invested in the residential plots by obtaining loans proposed by JIL or JAL in the National Capital Region and was possessed within 30 to 36 months of the booking. The sale agreement was given by the JIL and JAL also, because both are under the same group only. And they are promised to give the houses within 36 months. For that, all the home buyers, they have obtained the loan, and bankers are also approved that the particular project, and the project is approved by certain banks, and they are pumping the fund for construction activity. Honestly speaking, the promoter is only the organizer. The funds are provided by the bank through the home buyers who are availed that a particular loan from the respective banks, and the land also not belongs to him. And he is only the organization or facilitator to complete that project, and with the help of whatever the engineers and other people are. Due to delay in handing over the possession, Numerous flat buyers filed consumer complaints before the state of a national consumer dispute redressal commissions. Because once the handover delay is 36, my dream home, most of the buyers' dream home is not completed within the 36. Once it is not completed, then automatically the interest to be paid by the borrowers, particularly the home buyers, to the banks. And once the repayment is not started, the accounts will be turned into non-performing asset. Once the accounts are turned into non-performing assets of the home buyers, their Credit Information Bureau of India Limited, that is CIVIL, will also spoil. It is not the mistake of the home buyers, it is a mistake of the promoters, the real estate promoters. The chain effect will be there. In June 2017, RBI stated that a published a list of top 12 defaulters. Earlier, as per Banking Regulation Act, RBI earlier they have issued guidelines. These 12 accounts immediately you filed with the under IBC like that. Later on, Supreme Court also given a judgment. The judgment don't interfere with the banking functions. You are the regulator. You have to regulate the activities, not direct the bank to file these 12 accounts or one account or like that. Immediately, the instructions are stopped by the Reserve Bank of India also. But at that time, okay, the RBI stated top 12 defaulters in the country, including GIL, which was declared to be a default. Out of the 12 top accounts, the GIL is also one of the biggest advance of the banks, particularly the IDBI Bank. An amount approximately 8,000 crores to its lender. All accounts are put together. It is 8,000 crores to the lenders. When the petition was initiated, home buyers is no longer standing in the CRP. In the time of the filing of the suit, they are not the part of the COC. Later on only the IBBI has issued the regulations to include the home buyers as they are also in the particular CIRP process and committee of creditors also. Because of liquidation, the disposal of assets would not redress the grievances. Once there is no the resolution plan up to the mark, then liquidation. Once a liquidation happened, the ultimate sufferers are the home buyers. Why? Because at that time, there is no locus standi in the CIRP process of the home buyers. The locus standi is a right to bring action to be heard in the court, to address the court in the matter before. The court issued a notice on 4th September 2017 for proceeding before NCLT Ahmedabad to remain stayed against IDBI Bank filed application for a break. So the court issued notice, no, don't give any judgment, don't give any liquidation process, all these things for the time being, you put a hold. They put it on hold. That is on 4th September 2017. That a court is given the instruction to NCLT Ahmedabad, the Allahabad, remain stayed against the IDBI Bank filed in the application for a break. The Attorney General submitted before the court that the order stay would result in consequences where the control of a GIL would be restored to the arrestable management affecting rights of the creditor and consumers as well. Then the Attorney General told, once you have given the stay, the process will be halted. Once the process will be halted, against the management of a GIL will be taken over the company. And once that they have taken over the company, the rights of the creditor, consumers as well is badly be affected. That's why stay should not be given. In the meantime, IRP has handed over the records to the GIL also. Once the court has given the stay orders, then the IRP role is stopped and IRP, whatever the documents are there, records are there, all records are handed over to the management of the jail. The court modified the order. Immediately they recognized a small error or omission like that. Court modified the order 11th September and permitted IRP to take over the management of the jail. No, don't hand over the records to the jail. Take over the management of the jail and proceed formulate interim resolution plan within a stipulated time. Okay, you go ahead and whatever the process is done, continue, and the interim resolution plan to be finalized. The resolution plan to be finalized. The IRP directed to ensure necessary provision to be made to protect the interest of the home buyers. Okay, now you take in the resolution plan, whatever the resolution plan submitted by the prospective resolution applicants, you take into consideration of the home buyers, whether they are given due weightage to the home buyers or not. And the senior counsel nominated by the court participate in the meetings of the COC. And the court is also appointed one senior counsel who is also allowed to sit in the COC meeting. That is the court direction. Even though that is not there, but the court direction means we have to apply it. And JAL was a holding company of JIL and directed to deposit 2,000 crores on or before 27th October 2017. Because of being a holding company, that to guarantee given by the particular JAL for the loan taken by the JIL, and the equity also 51% pledge, the JAL, the shares are also pledged to the JIL for getting the loan from IDBI or other banks. The holding company JAL also directed by the court, okay, you bring 2,000 crores before 27th October 2017. They instructed the holding company also. And the mechanism evolved the court was intended to provide representation of the home buyer and secure their interest, and they were not given regard as a financial creditor. The mechanism evolved by the court. One mechanism evolved by the court on their own. At that time, that is not released, that home buyers is not part of the COC. At that time, court is also intended to provide a representation of home buyers. They should also brought into the purview of the COC, secured their interest as they were not regarded as a financial creditor in the COC. At that time, they are not treated as a COC. JAL sought vacation of the direction of the deposit of 2,000 crores. Or for modification that would enable JAL to transfer the rights of the concession agreement in respect of Yamuna Expressway, but the court declined to modify the direction. What is a concession agreement? The concession agreement, whatever the work in progress is completed, that process are to be deposited, whatever the 2,000 crores are ordered by the competent court, that funds are through concession agreement only we will pay, and modify the orders like that. Because 2,000 crores instantly they are unable to pay, particularly the JAL, the holding company of the JIL. A concession agreement is a contract that gives a company the right to operate a specific business within the government jurisdiction or another foreign property subject to particular terms. So normally the concession agreement infrastructure, and that is as good as escrow type mechanism. Not escrow, it is one type of escrow type. The court appointed amicus curiae. He was open a web portal, and the court also directed particularly they are also directed to start one web portal which details of the home buyers would be uploaded with a separate portal for home buyers of the JAL. JAL home buyers, all JAL home buyers are to be updated their particulars, their name, how much amount, when the sale agreement was reached, and what is the agreement date, and what is the terms, and all these particulars are to be provided by the individual home buyers in the portal. That is as per the court instruction. The web portal is also designed, and here the home buyers asked to update their information. And amicus curiae, this is a friend of the court, is an individual organization that is not a party to the legal case. He is not a party, that permitted to assist the court by offering information or expertise or insight the bearing of the issues of the in the cause. So that's why court is also thinking like that. And okay, how many people are there? How many home buyers? No clear-cut information. Some of the people are telling 20,000, some people are 18,000, like that. So that's why whoever home buyers are there, they have to update that full particulars, when they have paid the amount, how much installments, to whom they have taken the loan. All the particulars are to be filled by the home buyers. And it was informed that the court, after gathering the information portal, amount of 1,300 crores required to be refunded by the principal alone. Total, all people are uploaded the information. Once the information is uploaded, then the total claims to be paid to the home buyers by the particular JAL is 1,300 crores. Only the principal amount. And seeking refunds, they are asking, we require the refunds. Which according to JAL, 8% of the home buyers resting the seeking portion of the flat. 1,300 crores, they are asking a refund. Only the 8%, 92% of the home buyers, they are asking the flats. We don't require the refund, we require the flats only. But the 92% are require the flats, and 8% only 1,300 crores. You imagine how much funds they have mobilized from the home buyer. For 8% is 1,300, and if you that 100%, you imagine nearly it is 12,000 crores, like that. To redress the grievance, the home buyers, a direction was issued by the court warning the developer from raising demands towards the outstanding or future installment in respect of those flat buyers who had expressed a desire to obtain refunds. So, suitably, the court also given instructions. Developers don't raise a demand. They are asking a refund. The 8% people, they are asking a refund. Don't raise any demand from them. You have to pay back the amount to them only, or the future installment in respect of the flat buyers who are expected to decide to obtain refunds. The court allowed JAL request to submit the representation to IRP, one of the intending bidder in the resolution plan. The JAL, actually, they are going to participate in the resolution plan as a prospective resolution applicant. The court allowed JAL's request. JAL submitted, but the court allowed to submit the representation to IRP, one of the intending the bidders for the resolution plan. JAL also they proposed the court to permit alienate specific assets to secure compliance with the interior orders of they want to sell some property, alienate some property to deposit that 2,000 crores as directed by the court for payment of those who are asking refunds instead of flats, which were meted to despite numerous directions. However, it was gravely opposed by the other party. No. Once they are taking some property and selling property, then that is not good. So the other property is also not agreed. In the case of JIL, the period of completion of CIRP was extended by 90 days. 90 days, that is extended. That is actually whatever the 180 days is, 180 days extended to 90 days. The end is 12th May 2018. Because the process is not completed within 180 days, that's why the IRP requested based on the scenario, and they asked 90 days ended 12th May 2018. During that process, the IRP invited expression of interest. Okay, court has agreed 90 days, and the IRP floated as per the CIRP process. Specifying IRP must protect the interest of the home buyers. And court also directed you protect the interest of the home buyers, because here the home buyers are not taken into consideration. They are the ultimate sufferers. They are contributing the amount for the proper project, and even the financial creditor are also contributing, no doubt at all. But the home buyers are also their dream home not materialized. They have taken loan from the bank, and that funds are given to the builder. Builder diversion of funds was happened, or misappropriation of funds were happened. The court also clearly told whenever the resolution applicant, the prospective resolution, you have to see whether they are protecting the home buyers in the resolution plan or not. Must protect the interest of the home buyers and provide expeditious completion of the work construction. Because once the construction is not construction is stopped, then automatically lot of amount will additional amount will cost escalation will also happen. So immediately the court is also instructed suitably in this regard. Judge submitted resolution plan. Being an particularly the associate and the group head, John is also submitted. But as per this one, they are not eligible. But John submitted the resolution plan to which was found ineligible because of the section 29A of the IBIS. But they prayed the court allowed. But John submitted the resolution to which was found ineligible because of the bar contained in 29A of the IBIS. Today, 29A verification is one of the important area. And I'm taking the services of D and B, done and prostrate also. So whether it is whether they are defaulted or a disqualification of directors, whatever it is there, or any enforcement or FMO violations or whatever it is there, it is very difficult for the RP or IRP to verify the 29A of the prospective resolution applicants. Once we have given this project to a bad people who are not eligible, and then it will be again a problem to the all the stakeholders of the company. That's why thorough checking or due diligence is very much required for the prospective resolution applicants. So that's why sometimes I'm also taking the services of D and B, Dun and Bradstreet also in this regard. That is an international reputed agency. And if at all we are providing all the particulars, and definitely they will give a good report and valuable report that supports to your decision making process. It doesn't mean that a regulation not specifically mentioned about the D&B report, but it gives us some support for your decision making, or if at all any allegations or disqualification or any the directors or the non-performing assets of any other company, all these things they will give in detail. That's why that is also nowadays so many companies are floated, particularly in Bombay and other places also. But this is reputed institution with a lot of databases available for last 30 to 40 years like that. Because of being a banker, whenever we are financing to large scale advances, big advances, we will take the report of a D&B report on the directors of the particular company, etc., etc. Out of the rest nine, five were inconsistent. Out of nine, five were inconsistent. And the discussion took place for resolution applicants. Total 9 were submitted, 5 were inconsistent, removed, 4 was a resolution applicant. The COC decided shortlist of the resolution of Messrs. Lakshdeep Investment and Finance Private Limited, along with Sri Sudhir Walia and the relatives of Lakshdeep for a negotiation. So out of the 4, they have find out one resolution applicant, and that resolution applicant name is the Lakshdeep Investment Finance Private Limited. Meanwhile, George submitted the representation which was rejected as a result of a statutory bar contained in the 29A. Because they are also not they are also not repaid the loan to the bank. They are also defaulters. John is also defaulters. Their accounts out of 10 accounts or 20 accounts, whatever they is there, some of the accounts are turned into non-performing asset. That's why they are not eligible under for submission of the resolution plan under section 29A of the IBC code. And it's a failure to convince the COC its ability to tie up the funds for construction. And a failure to convince COC of its ability to tie up funds. How they are bringing that funds? Okay. They are rejected as a result of a statutory bar contained in 29A, correct? But they are not, whoever is there, the prospective resolution applicants, they have to tell how they are going to get the funds, how they are going to get the funds, whether any deposits are with the bank is there, or any tie-ups are there, or any the banks is proposed to sanction any loan, or any non-banking financial companies, they have to provide the proof. But they are failure to convince the COC of its ability to pay up funds, particularly for take over the resolution plan of Messrs. Lakshdeep putting vote only 6%. Okay. Out of 9, 5 was rejected. 4 out of 4, 1 is the best one. And the resolution plan was submitted, but the COC is not accepted. Only 6% of the favorite. Remaining 94% people, particularly the committee of creditors, not agreed to give the company to the Lakshdeep. And against 3/4 of the requirement which was needed as per section 30 subsection 4. Accordingly, IRP informed NCLT that no resolution approved by the COC and 270 days which is come to end by 12th May 2018. So 12th May 2018, that is going to be once no resolution plan or resolution plan not approved by the COC, or once it is approved by COC, not finally authorized by the adjudicating authority, then the next process is liquidation process. The total financial debt of the financial creditor on the date of commencement of CIRP is 9,984.70 crores. As per section 33 subsection 1 of IBC, liquidation falls on the rejection of the resolution plan. So the stage 2, stage 1 CIRP, stage 1 is not materialized, then it will move to the stage 2, that is the liquidation. So the total dues and particularly the insolvency commencement date stood as that is the 9th August 2017 is 9,984.70 crores. And 270, particularly 270 days is going to be over by 12th May, and no resolution plan. Whatever the resolution plan is they submitted only 6%, and a 2/3 majority is also not there, then the company has to go under liquidation. Then the sufferers are the home buyers. Then it is a deciding factor how to give the judgment by the Honorable Supreme Court in this regard. One side, 270 is over. Second side, the resolution plan are not approved by COC. It is a commercial wisdom, and the court should not intervene in that particular the commercial wisdom of the COC. And how to overcome the problem, how to safeguard how to protect the home buyers, that is a question mark for the Honorable Supreme Court of India. However, liquidation of JIL will not be subserve the interest of the home buyers. Once a liquidation is there, waterfall mechanism will start. The CIRP cost after that 24 months wages or whatever the security creditor, after that like that, then it is a injustice to the home buyers who who borrowed the funds from the banks and deposited the funds for their dream home in that particular real estate. The home is recognized to be part of a right to life. A home is recognized to be part of the right to life, and thus vital for the court to provide justice within the meaning of a fundamental constitutional guarantee. Whatever the funds are not their own funds. That is a borrowed funds with the rate of interest. And their once it is delayed, they are not paid timely on account of a non-occupation of the house. Their credit rating is also badly be affected, and they will not get in future loans also. All these things, side effects are there on account of this one. The home is recognized to the part of the right to life, and thus vital for the court to provide justice within the meaning of a fundamental constitutional guarantee. But here, the court has to they have to decide these are two important sections, how to accommodate these people, particularly the home buyers, how to give the justice, how to provide the justice for these home buyers. And these are two important sections. One is 29A, second one is 21, the COC Committee of Creditors. And the statute and the provisions, all these things, once again, they are going to review and finalize, and they have to give the judgment. Issues involved. What are the issues involved? Should the CIRP be initiated against the respondent in the present case in the light of protecting the interest of the home buyers? Against the respondents in the present case in the light of protecting the home, that is one. Arguments. What are the arguments? Arguments from the petitioner point of view, argument from the respondent point of view. What are the arguments for it? IBC recognizes three categories or classes, namely. One is corporate debtors. Second one is financial creditor. Third one is operation. That is section 7, 8 and 9 and 10 corporate debtor, financial creditor 7, operational creditor 8 and 9. The home buyers content not being protected by IBC. The rights conferred upon them, special enactment, including the Consumer Act 1986 and RERA, could not be deprived. They're eligible. They can file with the Consumer Protection Act, or they can file the irregularities committed by the particular builder with RERA. Suspension of the right to seek redressal before the adjudicating firm. Under section 14A, subsection A, clause A, 1 and clause A, leave the home buyers without remedy of the section 238 of the IBC gives overriding effect over the loss of existence. Actually, they have to move to the Consumer Protection Act. They have to move to the RERA also for their grievances if at all. But whether IBC is overriding the other acts or not. If at all difference is there, then IBC will prefer. If difference is not there, then that is the other acts are preferred. So the suspension right to seek redressal before adjudicating firm under section 14, subsection 1, clause A would leave the home buyers without a remedy as section 238 of the IBC give the overriding effect of the existence. The existence loss is consumer protection and the RERA Act is also there. Further, it was contended that the order of NCLT Ahmedabad being modified to enable IRP to take back the control. They are also contending. They are also asking, okay, again, the IRP has take back that particular, it was necessary to have the representative of the committee of creditors. Again, the square one onwards, the COC process to be started by taking into account of the committee, the home buyers in the committee of creditors also. The regime of act did not at the stage include the representation for the home buyers and the COC. The proposal submitted by Jal and Jill to the IRP opposed by the petitioners on the various grounds of the bar, section 29A, B, A2, B. Its inability to deposit the required amount. Opposed by the petitioner, no, we don't require the Jal and the Jill. They are already defaulters. They are already diversion of funds. They are already delayed the project. They don't have the skills to complete the project. Don't give that project again to Jal and Jill. And they are eligible under section 29A, B and G clauses. It's inability to deposit the required amount. Even when the court ordered 2,000 crores till date, they have not paid. The creditworthiness is not up to the mark. That's why the particular petitioners they opposed all these things. They ventilated their views to the honorable court. Reflects the financial crisis. They are in financial crisis, non-availability of the resources. That's why they are unable to pay the 2,000 crores, which render the impossible for them to complete the construction of the plaza. That's why, from our point of view, they are not competent persons to complete the project, even though they are telling that we are going to complete. Don't give. The previous inordinate delays showed the incredibility to hand over the houses to the home buyers. That is already experienced by the home buyers. Their incredibility. They are already faced, the home buyers already faced with the efficiency levels of the project, particularly the Jal or Jill. Arguments from the respondent. Petitioner's argument is also good, valid. And what arguments are by the respondent on behalf of the IRP? IRP is also ventilating his views. When asking the vacation direction to deposit 2,000 crores by Jal, the council of IRP drew the court attention to the fact that rights under the concession agreement being GIL was subject to proceedings under IBC, as a result of which a request for alienation could not be permitted. Alienation of the property should not be permitted. To the job for depositing the amount of 2,000 crores as ordered by the court. After refusal of the proposal, Jal and Jill to the IRP, the learned senior counsel on behalf of IRP submitted the essential. The court has two options before it. The court is having two options, option 1, option 2. They have to take a call. Which option is the best one to protecting the home buyers, as well as to complete the flats at the earliest. The first option is revive the CIRP process by extending the period of 270 days IBC. Already completed 270. If at all any disputes are there, another 60 days is provision is there. They can use that provision also. But to enable fresh consideration to be made to the prospect for resolution, which now have been taken into account of the home buyers. Okay. So don't allow them for liquidation. Continue CIRP and extended the time, and by taking into account of the home buyers in the committee of creditors. Option 2 would be for this court in exercise of jurisdiction under Article 142 to appoint a committee. Appoint a committee. Court is having always having powers to appoint a committee, and the committee decision to be taken into consideration. Under the directions to find the resolution that can stop the need of the liquidation of the corporator. To stop the liquidation process, alternative 1 is the CIRP continue by taking into account of the particular home buyers in a committee of creditors. Option 2 is appoint one committee. The committee recommendations of what they are going to tell. Second one is a time-taking process. In the meantime, the halt. Again, the committee has to study from the scratch onwards when they are going to give, even though deadlines are there, but deadlines, whether they will meet it or not, it is a question mark. The council on behalf of JAL also relied the second option. Actually, JAL, they are interested in second option. Why? Because to gain the time. Most of the builders, they prefer the time gaining. So once the committee is appointed, they will take their own sweet time to proceed outside the provisions proposed by the council for IR. Outside the provisions of the IR relied on the second option to proceed outside the provisions of IRP. That facility is not there. On behalf of Jill and John, what their views? Land Council appearing behalf of the John submitted the viewpoint of the developers. What are the developers are thinking about this situation? How to overcome that situation? John sought assure that double strength of the existing workers. Okay, sir, we will deploy number of workers, double the workers, and complete that flats, 21,522 home buyers flats. 21,522 home buyers means this 21,522 already availed loans with either public sector or private sector or NBFCs. They avail. Banks will not stop the interest on that particular amount, the loan amount. Once they have not started the repayment, their credit rating will spoil. The CIBIL report will spoil. These are people, they are telling Jill or Jal, no, we will deploy number of people and we will complete that 21,532 home buyers flats and complete it and within the whatever the court orders extended time. So Jal sought to ensure that double the strength of the existing workers for the construction of the projects. As a position is left to provide 21,532 home buyers. Jal sought permission to dispose of certain assets because they are not having funds to complete that 21,532 flats. They require some funds. For that, they are asking the court to give me permission to dispose of some of the assets. Then whatever the funds we are going to receive, with that particular funds, we will complete the project. To deposit post-dated checks of 600 crores with the registry of this court. For that also, they will give the checks. Why checks? Because in case any default is there, if the checks are presented and if at all it is bounced and the checks are given by the directors under section 138 to 142 of the Negotiable Instrument Act 1881, they are criminal cases can be booked by this one. Jal seeks to continue stay of a liquidation proceeding against this depositor and the direction of the court allowing the IRP to remain in the management. Judge seeks to continue the stay of liquidation against this deposit and the directions of this court to allow IRP to remain in the management. Everybody, the COC, they are ventilated their views. Home buyers, they are ventilated their views. IRP or RP, they are ventilated their views. And the different views are expressed. All these views are listened by the Honorable Supreme Court. So Judge seeks to continue stay in the liquidation proceeding against the deposit and the directions of this court allowing IRP to remain in the management. Okay, sir. IRP to be continued. He is supervising the our activities, whether we are going to complete, whether we are doubling the workers to complete the flats of 21,532 flats. It is submitted that the expiry of timeless prescribed IBC for the CIRP, there should be the liquidation process. However, it is not in the interest of the home buyers. It is not interested. Once the liquidation is happened, then the ultimate sufferers are the home buyers. Thus, only the suggestion to be envisaging argument outside the provisions of the acts. These are the solutions. So the court also, Honorable Supreme Court, they asked, what is your opinion like that? And accordingly, that's why the brainstorming is required instead of taking a unilateral decision. Okay, finally, they will give the verdict based on the different opinion and they will make a conclusion taking into consideration of justify the home buyers' demands or the CA and the whatever the IBC code or the regulations, etc., etc. It was contended that the project should not be stopped in midway, and the role of the developer JAL should not be discounted to protect the interest of the remaining 21,532 who await possessions. Today, people are suffering a lot, particularly the home buyers are suffering a lot. Being a banker, I know, even in Hyderabad also, one project, the loan taken from the bank and deposited with the real estate builders, the real estate builder contesting for MLA, member of Legislative Assembly, and the funds are, the deposit funds are diversified to that particular position, and the liquidity problem arises. that account turn into non-performing, and thereafter, after 6 years of the due date of occupation, again the home buyers, after a lot of fighting, without any mistake from the home buyer's point of view, their rights are preserved under the real estate. These people are telling their rights are preserved under real estate. How many real estate RERA people they are participating in their complaints? Even earlier also I discussed about Madhya Pradesh, one real estate case. So how many RERA? Okay, they are brought to the notice of RERA or consumer farm. Again, they will take their own time, process time. It has submitted that the independent committee of experts should be constituted by the court, evaluate the finance, continue to execute in the ongoing project. Okay, we will continue. We will construct with doubling the manpower, and you install you put some one committee, independent committee of experts, particularly the civil engineers or the who are worked and retired from the particular government organizations. It is also submitted the following opening of a web portal under the direction. Only 8% of the home buyers are opted for refunds, while 92 chosen not to claim the refunds. Once the people interest is not to get the refund, and 92% they are going to occupy the flats, means this is our views like Jol and Jill. They have ventilated their views to the Honorable Supreme Court, thereby implying confidence in the ability of the JIL to complete the project. Once the 92% of the people are willing to take the flats instead of refunding the amount, they are having, these people are trying to convince to the court authorities that we are competent people. That's why they are ready to take. No, that is not based on this percentage. It is not to be believed that a Jill or Jal is not a competent people. They are ventilating their views like that. So 92% of the people are ready to they occupy the houses, means they are having some confidence on the construction group. Judgment. Finally, after receiving the information or suggestions from the various stakeholders of that particular the case, finally the Honorable Supreme Court, they have given the judgment. To secure the justice, court held that the corporate insolvency to be reviewed, revived. Revival is very, very important. And the Council of the Creditor reconstituted as per the amended provision including at the time of the Section 7 filing by the IDBI, at the time home buyers are not the strict not the part of committee of creditors. Now, after 270 days are over, by the time only the home buyers are come into the picture, but they are also the part of the committee of creditors. So to secure the justice, the court held that CIRP should be revived and the Council of Creditors reconstituted as per the amendment provision of the includes the home buyers. The IRP is permitted to invite a fresh expression of interest for submission of the resolution plan, and the court is disallowed the JIL and JOL to participate in the CIRP. So the final judgment is given like this: revive the CIRP, there is no problem. And in the reconstituted CIRP, take the home buyers, because now they are eligible the part of the COC, and the IRP is permitted to invite a fresh expression of interest for submission of the resolution plan, and 29A they are not eligible. They don't have the creditworthiness. How to believe? 2,000 crores they have not brought. They are not competent to complete the project. So how to believe the earlier experience that 21,532 flats they have not delivered in time. So that's why they are not competent. That's why they should not. They are not eligible to participate in the particular resolution plans also. Article 142 empowers the Supreme Court to pass any decree or order necessary doing complete the justice in any case or matter pending before it. These decrees or orders are enforceable across the India's territory, making them significant tools for judicial intervention. So, Article 142, the Supreme Court of India, Honorable Supreme Court of India, they are having these powers. So that's why the CIRP is to be revived. These people, particularly the JIL or JAL, they are not competent, they are not sound, and they are not creditworthiness. Even though so many times the court ordered till date, they have not brought, they deposited rupees 2,000 crores to the court authorities. Based on the experience, past experience, these people are not competent to submit the resolution plans. Recourse of the power under the Article 142 allowed the present stage is a limited purpose only for this case, recommending the resolution process afresh from the stage of appointment of IRP by extending the period which has been prescribed for the completion of the resolution plans. In exceptional cases, another 60 days is having 270 plus 6330. The court held that would not be appropriate for the court to appoint a committee outside IBC. The court should not appoint. To oversee the CIRP, assume the task of supervising work of the committee. CIRP is as good as a committee of the CVC is a committee of creators. Once again, about the committee, one more committee is not viable or feasible. So the court held that would not be appropriate for the court to appoint a committee. CVC is a committee. One more committee above the committee, that is not good. Oversee the CIRP, assume the task of supervising the work of the committee. Ratio descendi. Ratio descendi is a Latin word, rational for the decision. The decision is given by the Honorable Supreme Court, that is called judgment. What factors that are contributing to give the judgment? The terms is a key factual points. The chain of reasoning the case derives from the final judgment. Based on these facts only, the final verdict was happened. So that's why here, what are the sequences? How the sequences are favoring the judgment, that we have to look at. In the light of IBC, the court has decided upon the protection rights to home buyers which were not protected on IBC initially. The point one lingering in the minds of the judgment, particularly the Honorable Supreme Court of India. In the light of IBC, the court has decided upon the protection rights of the home buyers which were not protected under IBC initially. Today, even a Minister of Corporate Affairs also, they wrote one letter to the Minister of Finance. There is a tailor-made IBC is very much required for real estate projects. People are suffering a lot. Real estate is a backbone to the economy because here, once the real estate sector growth is there, economic development will happen. The economic development means once the real estate growth is there, the cement industry growth will happen, steel industry growth will happen, particularly the paint industry or the electronic industry like the particularly ACs or lights, all electrical items, all demand will increase. Not only beyond all these things, it creates a lot of employment opportunity. That's why the government is also giving a lot of importance or priority for real estate sector. So the home for each family and the dream home to be delivered to the home buyers on time. That is possible once the funds are not diversion. Second one is the skills are to be exhibited. In the light of IBC, the court decided upon the protection to rights of the home buyers because that mistake is not them. The mistake is the builder. The builder taken the amount, not delivered the goods. That is whom. However, by the Insolvency and Bankruptcy Amendment Ordinance 2018, which came into the 6th June 2018, the home buyers came to be recognized as a financial creditor. Subsequently, they have given subsequently they are eligible. But at the time of the CIRP commencement date, that is not there. That's why they are denied of that particular provision. Due to the amendment, amount raised from all ARTs under real estate projects are started regarding the financial debts. Such allot is brought within the purview of the definition of the financial creditors. Section 7 of the IBC creates statutory rights in favor of the financial to initiate the CIRP. They have clearly spelled out after the amendment. Being a financial creditor under IBC, allottees of the real estate project necessarily constitute because their feelings and their voting are also to be taken into consideration because their funds are also major funds in the total project. Okay, financial creditor funds are also there. When compared to this particular financial credit, the home buyers advance payments are more. Financial creditors are entitled to voting the share proportionate to the extent of the financial together with the 80%, 8% interest per annum. Whatever the advance given by them to the particular builder, that amount plus 18% interest also they to be taken into consideration to decide the voting right. On 31st of July 2018, a circular has been issued by the IBCPI, Regulation 16A, facilitate processing of appointment of authorized representative on behalf of the home buyers. That is called class of creditors under Section 21A, 6A or B of the IBC. The proposal submitted by the IRP on behalf of JAL, not accepted by the court, referring to 29A. Because the proposal submitted by the IRP on behalf of the JAL is not accepted. Why? Which was brought with the intention to ensure the persons who are responsible for insolvency do not get to participate. They are responsible. The JIL is responsible, JAL is responsible for initiation of the CIRP. Because once they have given the flats in time, once they have paid the amount to the financial creditor, the situation is not arise. They are responsible for this particular the CIRP process. The participation of such persons would undermine the valuable object of the purpose of the act. So that's why they are 100%, they are not eligible to participate in the resolution plan. Keeping this in object in mind, 29A creates a bar on the eligibility. Bar on the eligibility. Section 30 of the IBC, as amended, also clarifies that the resolution plan if a person is ineligible under section will not be considered for by the COC. Section 29A, C and G prohibits JIL and JAL being allowed to participate in the resolution. That's why they are not eligible. The court also recognized lack of financial capacity. They are not having the financial capacity. Why? Because they are not unable to bring the 2,000 crores as directed by the court. And the resources are completely unfinished projects. Once the projects are finished, 21,532 flats are not delivered in time means their inefficiency. They are not efficient. They are not skilled. They are not having the liquidity position. They are not having the creditworthiness. They are unable to bring the 2,000 crores also. Unfortunately, by the time of ordinance came into being, that is 6th June 2018, which confirmed the statutory of home buyers as a financial creditor 270 days has been expired. And the resolution plan of Lakshadweep was rejected by the COC with a 6% voting rate only. 94% of the people, they are not interested to hand over these projects to Lakshadweep. And IRP informed NCLT, no resolution plan. Once a no resolution plan or resolution plan not approved by the COC or approved by the COC and not finally authorized by the adjudicating authority, then the next step is a liquidation. Approved within the extended period of 270 on 12th May 2018. The court held that CIRP should be revived. Only the alternative available, the best alternative available by taking into consideration to protect the home buyers, only one alternative available or rest with the Honorable Supreme Court is a revival of the CIR. Reconstituted as per the amended provisions, including the home buyers. It would be open IRP to invite fresh bids except JAL, which is barred under section 29A. The home buyers have earnestly sought issuance of interim directions, pro rata disbursement of the amount disbursed, deposited before the court, amounting 750 to those home buyers who seek refund. And whatever the amount they are asking a refund, that is also interim direction facilitator. The pro rata disbursement of the deposited before the court amounting 750 to those, whatever the receipts are there, the receipts, the home buyers earnestly sought the issuance of interim, they are asking interim orders. However, during the pendency of CIRP, it would be impermissible for the court to direct the preferential payments. They are asking, whatever the 750 crores are there, my lord, please refund that amount in a pro rata basis. No, it is against the violation of the code also. Impermissible for the court direct preferential payments being made to the particular class financial where there is a secured or unsecured. It would also be unfair to the interest of 92% of the home buyer, many of whom would also be obtained loans to secure a home. If at all that a payment is made, then it is unfair or injustice to the 92% of the home buyers. Even concepts of the secured debtors like IDPA have to be taken care of. If at all that a payment is made 750 crores for those who are not interested to take the flat, it is an injustification for IDBA being a secured creditor that to financial creditor, or 92% of the particular the home buyers who are interested to take over the flats. Once the payments are made, then automatically the funds will not be available. Thereby, halting of the project will happen. All these things are also to be taken into consideration by Honorable Supreme Court while giving the judgment also. Moreover, Jill was one of the 12 accounts. In respect of directions have been issued by the RBI to banks initiating insolvency as per the regulation amendment. In the meantime, at that time, the Reserve Bank of India also ordered, then that's why the court has to honor the directions of the Reserve Bank of India. And JAL was entity was more than 60% of the accounts classified as NPA. The JAL accounts loans availed by the JAL from various banks or NBFCs, 60% of the loans are turned into non-performing assets. In that case, how they are eligible for submission of the resolution plan? And no viable resolution plan within 6 months could be found. The result of which was to be referred to the CIR. JAL was classified as a special mentioned account 2. That is a special mentioned account 0, special mentioned account 1, special mentioned account 2. If the loan is not paid within 30 days, SME 0, and 31 to 60, special mentioned 1, and 60 to 90, 61 to 90, 2. All the JAL accounts are classified by the lenders under SME 2. And as on the 3rd October, and NPA since 31 March 2015. After witnessing the financial distress of JAL and JIL, the court found it reasonable on behalf of IPA to allow the follow the recommendation of an internal advisory committee to initiate CIRP against JAL under the IBIS. So that's why the Reserve Bank of India, based on all this the information, they have directed the banks to file the case under IBC. So this is in brief about the first case, sir. Am I audible, sir?
Yes, sir.
So this is the first case. So today, the particularly home buyers, they are facing a lot of problems. So whenever we are handling the cases of the infrastructure loans, particularly the real estate builders, most of the accounts are turning to bad also. Even in Hyderabad also, some of the projects are turning to bad and they are defaulted with the banks. They are defaulted with the home buyers also, not giving the homes, the flats in time. And whatever the due dates are there, they have not fulfilled that due dates. Thereby, this type of problems are happening. And we have to handle the case by taking into characteristics of the real estate, particularly what are the characteristics and what is the sale agreement, what are the stage-wise disbursement, and how much funds they have taken from the bank, and what are the terms and conditions of the loan. Whenever they are asking the installments from the home buyer, what is the conditions of that particular this one, whether they are fulfilling all the RAMA guidelines or not, whether they have opened the escrow account or not. Once they have not opened the escrow account, this type of problems will happen. And this is in brief about the case number 1, sir. And we will break for tea for 10 minutes. After that, again, we will discuss about case 2 of the Supreme Court of India. Is it okay, sir? Shall we break for tea, sir? Hello?
Yeah, sure, sir.
Okay, sir. Sir, shall I start now? Sir, this is case 2.
Yes, sir.
This is also Supreme Court of India judgment. This is also relates to the real estate only. Particularly, the worry is the home buyers are to be protected. That is the hard-earned money of the home buyers. And if at all they borrowed and given the amount, and if they are not the part of the committee of creditors, then ultimately they suffered a lot. Today in the corporates, if the company is floating bonds or debentures or fixed deposit, different series, they are called as a class of creditor. In the company, particularly in the real estate company, these people are also contributing a lot. To my knowledge is concerned, particularly the home buyers are contributing a lot. And beyond the financial creditor, they are contributing a lot. And with the help of their contribution only, they are purchasing the cement or steel or whatever the labor payments, all these things are paid by the real estate people with the help of the people. Most of the banks are also not financing to the real estate because they are getting the funds mostly from the advance payments of the particular the home buyers. So this also Pioneer Urban Land Infrastructure Limited and the Union of India. This is also the real estate, and this is also Supreme Court of India, Honorable Supreme Court of India judgment. And we will discuss this case also. And this case is also to protect the home buyers. The Supreme Court of India in Pioneer Urban Land and Infrastructure Limited upheld the constitutionality of the Insolvency and Bankruptcy Code. That is 2018. This act included real estate allottees as a financial creditor under section 58F of the IBC code. This act included the real estate allottees. That is a must also. That is a need also. That is a justice means these people should be the part of the committee of creditors. The real estate developers who challenged the amendment, normally, once it is not favored for them, definitely the real estate builders, they will challenge. Amendment argued that it is a discriminatory violator of Article 14 of the Constitution of India, which guarantees the right to equality before the law. The real estate developers, they are argued. In COC, why you are including the home buyers are not eligible to participate in the COC meeting. They are not the members. They are also argued amendment was not in line with the objectives of IBC, which is a maximum value of the assets on behalf of all creditors. Once the financial creditors, they are getting the priority of a payment when compared to the operational creditors. Today, whether the home buyers are secured or unsecured, it depends upon the sale agreement. It depends upon the sale agreement. That the undivided share, if at all it is registered in the name of the particular home buyer, is to be treated as a secured creditor. So it depends upon the sale agreement that is given by the real estate builders. The home buyers are to be treated either secured or unsecured. The Union of India, on the other hand, argued that the amendment was necessary to protect the interest of the real estate allottees, who are often vulnerable to exploitation by the developers. This is true. Otherwise, in the earlier case, 21,532 flats are not delivered, even though they have taken as an upfront amount, which is not good enough on the part of the real estate builders. 21,532 into average, if the building and the flat cost is 60 lakhs, 50% already deposited, or some people 90%, some people 80%, and some people 95%, only 5% to be delivered, to be paid at the time of occupying the flat. Almost all amount they have taken, but that product is nothing but the dream home is not delivered to them. So that's why they are vulnerable to exploitation by the developers. This is not only in these cases. Number of cases are there. Number of cases. Even I am the eyewitness for that. This one. The government also argued that the amendment would help to improve the efficiency of insolvency resolution process. Once you have taken only certain people, only the financial creditor or the class of creditors like bonds, debentures, and fixed deposits, these people also contributed money for the development of a project. Why these people are to be deprived to participate in the COC with the help of under the class of creditors, under the representative, through the representative, and boost the investors' confidence in the real estate sector. Once this is included, definitely it is a positive point for the real estate. Otherwise, if 2 or 3 cases are happened like that, and the particularly the buyers, home buyers are not getting any amount, the real estate sector will not develop. The fear psychosis is there among the buyers. Once I paid, whether I'm getting the flat or not. Even I purchased one flat. After 3 years, they have given the scheduled time only, correct? But up to 3 years, I am always in tension whether they are giving in time or not, whether they are stopping that one or not, I don't know. Even though the bankers are believed that a particular builder, some of the builders, their diversion of funds are more in the real estate sector, particularly in the builders community. For all artists edition in Pioneer Urban Land Infrastructure, Union represents a turning point as it grants the authority to join the committee of creditors on the same conditions as banks and financial institutions, in addition to enabling them to enforce the code. They're also having the particular power to file an application with the NCLT under Section 7, either 10% of the total this one or minimum 100, they can file. The judgment also a positive impact on the real estate sector as a whole. The boosted of investors' confidence has made the sector more attractive to foreign investors also. Once the buyers are also participated, then the discipline will happen on account of the real estate builders, the two real estate builders. Discipline. Once it is not completed, then the home buyers will approach the NCLT. And if at all these riders are there, definitely those who are invested, that is the FDI, foreign direct investment in real estate sector, will also boost it like anything. The ease of doing business. Today, the India's rank is 63. Before implementation of IBC, it is 144. After that, 142. After that implementation, it reduces to now it is 63 on account of IBC and on account of one nation, one tax, that is GST. So the reforms, the foreign direct investment based on the reforms only. Investors' confidence made attractive to the foreign investors also. Once the foreign investment is there, then the growth will happen in the country. Facts of the Pioneer Urban Land and Infrastructure Limited and Union of India. In response to the Insolvency Law Committee report, which was published by the Minister of Corporate Affairs in March 2018, that is, the second amendment was passed by including the home buyers in Committee of Creditors. The recommendation was based on National Company Law Tribunal NCLT in Nikhil Mehta Sons HUF versus AMR Infrastructure Limited. That is the base. That is the base. Particularly the Insolvency Law Committee report, they are also recommended that the home buyers should be the part of the Committee of Creditors based on the Nikhil Mehta and Sons versus AMR Infrastructure Limited. In this instance, allottees who signed assured returns, committed returns. That's why, being a resolution professional, whenever we are handling the real estate projects, CARP of real estate projects, we have to study the standard covenants or terms and conditions of the sale agreement that is issued by the promoters of real estate to the prospective buyers. What are the conditions? Whether interest clause is there or not, when he is going to allot, and what is the installment. Next, once the timely not given, how much rent he is going to pay. Some of the real estate builders, they will tell, once I am unable to provide the flat on a scheduled date, per month, I will make a payment of 30,000 or 20,000 as per market practices like that. So we have to go through that sale agreement. Issued returns also, some of the people, once I have not given, I will pay the rate of interest from the day one onwards like that. And committed returns, contacts with the developers, wherein the developers are committed to paying allottees a specific amount each month starting from the date of contractor's execution in exchange of receiving the sizable portion of the total sales consideration upfront at the time of execution. At the time of execution, whatever the terms and conditions are there, once it is not materialized or fulfilled by the developers, then some of the developers in agreement itself issued returns or committed returns. In my case also, whenever when I have purchased the flat, we will the home they allot we will deliver the flat on so month, on so year. Once we are not given, then from that month onwards, we will pay monthly rent of so or the interest or whatever the compensation also they will mention. The money developers received under the guarantee return scheme had a commercial impact on the borrowing. That's why they are treated as a financial creditors. Demonstrated the amount of the committed payments under the heading finance charges in their yearly reports also. Some of the builders, how much compensation they have paid if they have not delivered that particular flat on time. The proposal of amendment were made in the lights of this. On account of this only, the law committee also decided, okay, this is a commercial impact of borrowing is there. Once commercial impact is there, definitely that is to be treated as a financial creditors. As a result, Honorable Supreme Court has received many writ petitions challenging validity of the 2000 amendment, particularly from the builders, because it is not a favorable point to the builders. According to the report prepared by the Insolvency Law Committee, dated 26 March 2018, a significant number of writ petitions have been filed court challenging constitutional validity of amendments made to the insolvency herein after the court. Actually, final product we are enjoying now as a insolvency profession. But a lot of homework, lot of the exercise was done by the Honorable Supreme Court after receiving all the writ petitions on this validity of this point. The aforementioned modification designate allottees of the real estate financial creditor, enabling to pursue the legal action against the real estate developer under Section 7. The carelessness is arrested. So once it is not even 10% of the total home buyers or 100, whichever is less, they can file an application with NCLT. Now they are alert. So the threat is not only from the financial creditor or operational creditor or class of creditor. Now the threat to the particular real estate project promoters from the home buyers also. Why? Because they should be alert. Once they have taken the amount, it is the basic responsibility to provide the house to the buyers on time. Further, they have right to have the authorized representative also. They can appoint authorized representative. Then to the committee, they are financial creditor because they are financial creditor. Why authorized? Because if all home buyers are assembled in the committee of creditors, then it is very difficult to control, to manage, to get the things done. That's why via through authorized representative, whether it is a bond holder or a debenture holder or fixed deposit or the home buyers. Issues. What issues were happened in this case? The issues raised in Pioneer Urban Land Infrastructure Limited and the Union of India, whether home buyers can be considered as a financial creditor under IBC Code 2000. That is point one. Whether explanation added, why? Because the financial creditor definition is the Section 5 BF clarify enlargement of that particular section. The financial creditor is defined in the Section 5. That enlargement is eligible or not. These are to be included or not. Next, whether IBC will have overriding the effect of RERA. RERA is there. Consumer forms are there. That is a district level, state level, national level. Consumer forms are there. They are having a right to file an application with the consumer forms also. RERA, the real estate regulatory authority, is also there. Once these facilities are there, why should we take as a financial creditor under committee of creditors in COC meetings? That is the question mark. That is points arised in the minds of the judiciary authority. Whether constitutional consideration of home buyer violates the article the 14 or 19(1)(g) or 300(a) of the Constitution of India, particularly the freedom of speech to present the profession, or no person shall be deprived of the properties saved by the authority of law. All these things are there. Arguments in Pioneer Urban Infrastructure. Petitioner side, what are the arguments were happening? Respondent side, what are the arguments? What is the judgment? Arguments in petitioner side. What are the arguments were made? The recognition of LRTs as financial creditors has raised concern regarding the compatibility of Article 14 on two fronts. First, it is perceived inequitable because it treats a minority group unfairly and pieces differences without any clear differentiation. These people are minority people. And unfairly and pieces difference. Second, integration of LRTs in this category considered lack of alignment in overreaching the objectives of the court. From the petitioner side, they are arguing like this: equality before law under Article 14. Moreover, the revisions have been criticized not promoting code principal aims, which is centered optimizing or maximizing the asset value shield of the corporate data shareholders from the ramification of ineffective and the clumsy management. That is not whatever the petitioners plea is there. That is not correct. They are also funding. The growth of the real estate sector is depending upon the buyers of the homes only. If at all buyers are not there, then there is no real estate sector. Once the people are they going to purchase to have a house, then only the process will start. Otherwise, no process. They are the key person. They are the main customers of this one. Banks are providing operational credit or supplying the cement or steel or whatever the other this one is there, or labor they will, but the key person is the home buyer only. But petitioner is telling so many things, constitutional validity and all these things. He will comment. Critics have put forth the argument amendments appear arbitrary, excessive, disproportionate, devoid of a rational foundation. Arguments are like that only. They will tell this is not correct, sir, that is not correct, sir. They contended that the changes potentially infringe the constitutional rights of the petitioner under section so and so of the Indian Constitution as a modification, unconstitutional, not reasonable constraint grounds of the public interest under the Article 19(6). They will tell, sir, this is not correct, sir, that is not correct. But what is correct? Once he is paid the amount and the advance amount, he is having a right to take over the asset. With his funds only the real estate growth is happening. With his funds only the construction is happening. With whatever the assets are there, it is contributed by the home buyers also. Additionally, the adjustments made in section 21 and the introduction of the 25A in the code are seen primarily favoring commercial judgment of the Committee of Creditors, further accentuating the apparent arbitration of the changes. The petitioners are arguing like this. Another contention issue revolves the real estate regulation, comprehensive regulation. Once that is a comprehensive regulation is there, why you are included in the Committee of Creditors as a members? Like that, the petitioners are arguing, addressing the complexity of the real estate sector. The technicalities, timely not delivered, escrow account and penalty, all it is the regulator will take care of. Why these people are part of them? Correct? But without him, there is no real estate sector. Without his funds, no bank will give the loan. Total funds are not provided by the bank. And whatever the advance amounts are taken, they are not, after construction, they are not selling. Before construction only, they are selling the flat and they are taking. Some of the builders, oh, that sky, that is a 30th floor, you are going to get after 3 years. In the meantime, you pay 50% of the advance. Or a 30th floor, when it will come after 3 years. In the meantime, he will show the sky and he will take a 50% of the total amount. And for that sale agreement, and the physical asset is not visible. All these things, then, well, okay, this is a hard-earned money of the home buyers, if at all own funds are there. Or some home buyers, they are taking the loan and giving the advance for construction. Even though RERA is there, that is a secondary one. Primary one is he is given the finance for construction of his flat in the real estate building. It provides a mechanism, adjustment disputes between allottees and developers. That is a mechanism is there in RERA. When it will take, and what is the deadlines? All these things are there. Offer wide array of provision favorable to the allottees. But how many cases are filed under RERA, and what is the outcome of the RERA? Including provisions of substantive agreement and application amendments. Today, different builders are practicing different ways. How many people are opening the escrow account? Once I have given the advance, that amount to be deposited in escrow. Whenever they are purchasing, particularly for construction of that my flat, then only that funds are to be utilized. Where is the control of escrow account? How many states the RERA is implemented in strict, and natural justice is required, particularly for home buyers. Critics argue that this act is potentially supersede any prior agreements between the allottees and developers. They are always thinking, they are always talking like that only. Hence, a careful analysis of Real Estate Act reveals that the potential redress all the concerns voiced by the allottees, thereby underscoring the argument that the contested modification, excessive, disproportionate violation of Article 14 or 19(1)(g) of the Constitution. The petitioners are arguing like that. In my personal opinion, that is not correct. Being a banker, that so many projects are funded by none other than home buyers only. The land which is going to be constructed, the flats, that land also not belongs to the promoter. He is a facilitator. He is organizer the people and assembling that one and constructed with the help of the funds received from the home buyers, from the respondent side. Petitioners always are telling this is not good, not justifiable. It is the only one way they are thinking, and not the real estate side. Today, real estate people afraid. Some of the real estate people, they are afraid of most of the real estate people. Now they are aware of the IBC in total. What is the consequences? In each and every metros, towns, the real estate builders, the knowledge about IBC, the fear psychosis there in their minds. Earlier, if at all a loan is defaulted, then only bankers will approach. Today, operational creditor, class of creditor, and beyond all these things, the proper publicity is also required. If it is published by the government of India to the public, if any real estate builders are doing like this, you are having every right to file a case against him under IBC for refund of your amount like that. The respondent side. What is the respondent side? Insolvency Law Committee uncovered the prevalent issue in the construction sector. They have not covered. That's why they have covered, namely frequent delays, completing apparent flats projects, which are often funded by the payment collected from the property buyers. That is the correct notion about the insolvency law committee. Completing the delays in completing the projects. The funds are belongs to the home buyers, not by the promoter. He is utilizing the funds of the buyers. It is crucially acknowledge home buyers as financial creditor to grant them right to invoke under Section 7 of the code. Have voice to pivotal decisions. They can raise the voice because their funds are there. The buildings are constructed with their funds. And the construction of business projects as they have been, okay, financial creditors are there, undoubtedly. But their amount is small amount when compared to 22,532 in that JIL or JAL, 22,532. Flats means into, if you take average 30 lakhs, that much funds are locked with the real estate properties. The code is a real estate regulation, RERA, operate in distinct domains. It is not exclusively on this domain, particularly to safeguard it is one of the area, not the sole area of the RERA, to protect the buyers. To protect the buyers is one of the area, not the sole area. The code primarily focuses on reviving corporate data through settlement procedures, aiming benefit the involved stakeholders. On the other hand, RERA primarily serves to safeguard the rights of the private real estate investors by enforcing stringent developer standards. Pollution is there, timely completion is there, get the permissions from various quarters. So many things are there in RERA. Only RERA is not only for home buyers. The protections provided under RERA are supplementary rather than exclusive. Only supplementary. Once the home buyer is suffered, then only he will approach. Then they will take their own sweet time to resolve their issues. In the meantime, the interest accrued in the loan account of the home buyer. And in the meantime, if the handover of the plot is delayed and the returns, all these things, problems are there for the home buyers. Hence, RERA and the code should be coexist. With RERA taking the precedence in the event of conflict. The modification of the code were responsive to the public demands. It is not simply on their own. They have not made the law committee. They have not made on their own. Lot of representations are made by the public. These builders are doing like this. My funds are utilized. With my funds, they have constructed, but a flat is not delivered and misappropriated funds diversion, all these things. Challenges recognized by the insolvency law committee. They have, we listen. Some of the members may also face the problem. These challenges align with the court's goals by classifying LITs as that's why they have given the instructions to modify the regulations and to include in the code under Section 5, the financial creditors, the extended the definition also. Importantly, this classification confirms the Indian Constitution, Article 14, and 19(1)(g) or 300(a). They have taken into consideration, they have studied all these things, and accordingly they have given the instructions to the IBBA to include this one, and suitable amendments were also made. Home buyer should be regarded as a financial creditor. Similarly to individual financial creditors such as the debenture holders, fixed deposit holders, given the substantial contribution in the financing real estate projects. Once they have given particularly debentures, they are also funding the particular project. Bonds also funding the project. The home buyers also funding to the project. Why they have deprived of this one? Furthermore, project alloters must meet the criterion of the consideration of the time value of the money to be recognized as a financial creditor. Here also time value. Once you told that I am going to give the flat on so-and-so date, then automatically the promoter, particularly the home buyer, will also estimate. If it will delay that, then the interest I have to pay to the bank. And I am not getting the revenue also. So the time value recognition is one of the preamble of that particular IPC code also satisfies here. That's why they are included in the COC. Ratio descending in the Pioneer Urban Land and Infrastructure Limited and the Union. What is the events that happened? The sequence, both sides, the petitioner side, the response side, they have listened. And what are the sequences? Based on the sequences and events, they have given the judgment. The Supreme Court in Pioneer Urban and Infrastructure Limited and Union of India acknowledges that the insolvency court plays a crucial role in enabling the corporate debtor, particularly the real estate, to succeed their endeavors. So that's why enabling the corporate debtors play a crucial role, particularly in the real estate, to succeed their endeavors. What is their endeavors? They have to fulfill. They have to deliver the flats. They have to fulfill the time norms. Once the amount is taken and the time value of the money is also involved in the process. The success of outcome from expense of unsecured creditor such as allottees properties. The prime objective here is facilitate proper management within the corporate data framework, which ultimately benefit the stakeholders and the public at large. That's why in Jill and Jal also, once the court has given stinkers, they told, I will deploy the double manpower workers and I will complete the project. Why not before the situation was happened? Why have not taken that measure by the corporate before filing the case in the NCLT? Once the project time schedules are not adhered, then it is a problem to the allottees. This approach aims that real estate projects are executed originally planned. In that case, what is the validity and the sanctity of the agreement reached by the buyer and the real estate promoter? Once he is not adhered or not completed the project, then compensation to be awarded. And he is having the right because he has given the advance that the flat or apartment buyers receive the properties promptly. They have to give the asset promptly. Once I purchased they paid the amount, particularly I have gone to that super bazaar. I have paid for that one toothpaste. I have paid, but the goods are not given means then it is not correct. Once I paid the amount, he has to give the good to me in the similar manner in the real estate also. In cases of delayed delivery or non-delivery, some other cases, non-delivery is also there. When I visited to Pune, one builder for the last 15 years, that is not completed and nearly 1,000 people, 1,000 persons, they have applied the loan and paid the amount as an advance. Now 15 years completed. Till date, it was not resolved. What is the humiliation the home buyers are facing? They have taken the loan, 1,000 people, and now the building is a dilapidated condition. That is also to be, that all these feelings are to be taken into consideration by the Honorable Supreme Court, and accordingly they have given the judgment. And the law committee also, they listen all these things before formulation of the code or the regulation. This approach to ensure that real estate projects are executed originally planned and flat apparent apartment buyers receive property promptly in cases of delayed delivery or non-delivery. Code empowers the management to provide compensation or refund the amount advanced by the allottees along with interest. Along with interest 8%. Whatever the advances they have given, that is to be paid back. If at all they are unable to give. In this context, Article 19(1)(g), the Supreme Court in Pioneer Urban Land and Union of India, IBC amendment, which was introduced, change to the code. Change is required. Does not violate this constitution provision of provision. Article 19(1)(g) pertains to fundamental right to carry on trade or business or occupation. But we should not give any inconvenience to anybody. The court asserts IBC Amendment 2000 enacted in the public interest. Public at a large, they are suffering. In Jill and Jal also 21,534 people suffered. Only one, I am talking about one builder. But in Madhya Pradesh also, Akruti builder. Akruti builder. Whatever the funds received, advances received, he diverted to other areas and he has not delivered that apartments to the home buyers. And whenever they are giving advertisement in a rosy picture with cine actors, brand ambassadors, all these things, they have cheated the home buyers, Akruti builders. That is also the NCLT case. There, the RERA is also fully involved in that particular case. The builder is using different tactics not to pay the amount to the home buyers. Once he has taken the amount, his primary responsibility to repay the amount with interest. If at all he is unable to deliver the goods or product, that is home. So, was enacted in the public interest and does not impose an undesirable restriction on the fundamental guarantee. The amendment is a core objective is to enhance the efficiency and effectiveness of the insolvency resolution process, contributing the economic growth and stability. That's why the preamble of IBC is the World Bank has given the instruction to all the countries, protect or save the credit, save the particular shareholders, protect the shareholder, protect the credit. If at all the shareholders not protected, then automatically in future, nobody will invest their surplus funds in the company by way of share capital. That's why the Securities Exchange Board of India was originated. Protect the credit. Once the credit is not protected or saved, then the loans will turn into bad Once the funds belong to the depositors, no depositor will deposit their hard-earned money in the banks. So the IBC is also the IMF or World Bank instructions to save the credit, to save the credit. Once the banks are giving credit to the companies or any business enterprises, if they are paid, then automatically they will give the loans to others. The recycling of funds will happen. Once this loan is turned into bad, then ultimate sufferer not the bank, the depositor only. The depositor funds the translate into advance by the banks. Bank is a mediator. If the borrower is not paid, the ultimate sufferer is a depositor. Once it is not effectively recovered, timely recovered, not recovered, then the sufferer is a depositor. Once the depositor faces the problem, no depositor will invest their surplus funds in the bank. Once there is no bank, no agriculture growth, no industrial growth, no service sector. In the similar manner, once the home buyers are not protected under the Act code, home buyers will not take the apartments. Once they are not taking the apartments, real estate growth will not happen, employment will not happen. So many side effects will be there. The amendment of the core objective is enhance the efficiency and effectiveness of the insolvency resolution process, contributing economic growth and stability. The court emphasizes that the pursuing the public interest, the fundamental rights of the petitioners are not unduly condensed. Further, the Supreme Court in Urban and Land Infrastructure Limited, Union India, no infringement of Article 300. Article 300 pertains to the right to property and state and no person shall be deprived of the property except by the authority of a constitutional valid law. In this context, IBC Amendment Act impact on the corporate debtor and unsecured creditor. The court finds the Act 2018 is a constitutionally valid law that serves the legitimate public purpose. That's why the home buyers are the part of the committee of creditors. They can participate, they can give their judgment, or they can give their judgment, their views through the voting to accept or to reject the resolution plans or whatever the other areas are there. It provides structured framework for insolvency proceedings, safeguard the rights of the various stakeholders. The stakeholders may be the financial creditor, the class of creditor, the home buyers, operational creditor, or the employees, or the workers, or the government, the dues to be paid to the government. So that's all under waterfall mechanism, all are listed. Fair and a transparent resolution process. If at all they have not taken into consideration, then it is not a transparent code. Consequently, court concludes that the petitioner's property rights are not violated on the provision of the IBC. In the essence, Supreme Court perspective underscores the balancing act between the interest of the corporate debtor and unsecured creditors, particularly LRTs of the real estate sector. Real estate balancing is required. Otherwise, malpractices will happen. The real estate builders will cheat the public also. That is happening in some of the states in India. Number of Akruti builder is a branded dealer and a branded real estate builder is also cheated like anything. The court, Pioneer Urban Land Infrastructure Union. Court's role is promoting timely completion of real estate project and protection of the rights of the property buyer. For that purpose only he paid the amount. For that purpose only he taken the loan from the bank. For that purpose only the real estate company is originated. It also upholds the constitution of IBC amendment, highlighting the public interest compliance with the constitutional provisions related to fundamental rights and property rights. What is the final judgment given by the Honorable Supreme Court of India in this case? That is a Pioneer Urban Land and Infrastructure Limited versus Union of India. The Insolvency Law Committee report proposal project to be funded with the money paid by the house buyer. That is underlined. Not by the buyer. Not by the operational creditor. Once they funded by the home buyer, then only he will purchase a cement or steel or etc. But some working capital gap may be there, that is funded by the banks. But most of the funds are contributed by the, even the operational creditor should not give any credit to the real estate sector. Why? Because already funds are coming from the home buyers. That funds are to be utilized for purchasing of various raw materials, etc. The Supreme Court said that it is paid in advance for a temporary usage of apartment to be returned to the lender. The money obtained under the terms of sale agreement between the house buyer and the developer, commercial impact of the borrower. Whatever the agreement reached between the builder and the buyer is a commercial agreement. Once it is a commercial agreement, why not we include in the financial creditors, that is SIVA, financial creditor. That's why they have included. That's why they are having the right to invoke that under section 7 of the IBC code. And they are also the covers under the definition of the financial creditor under section 5. Extended. The Indian Constitution Article 14, 19(1)(g) of the conjunction with the 19(6), 300A are not violated the Code Amendment Act. While inserting this section, the not violated by the court. The Constitution articles are not violated. It is recommended to read Code Revised Amendment in the combination with RAMA. The code will only supersede the RAMA in case of disagreement. Once a disagreement is there, then only it is coming to the picture. Till such time, no. The remedy is available. Those who have been allotted flats, apartments are therefore complementary with each other. There may be used the code or RARA and the consumer. Whatever they want, they can use it. It is a complementary. The court cited the rulings of Swaraj Infrastructure Private Limited, Kotak Mahindra Bank Limited, wherein decided winding up of procedures under the Companies Act and a debt recovery, all these things could be placed parallelly. The court also Pioneer Urban Land Infrastructure found the RARA and the code must be coexist. Under the event of clash, RARA must be given weight to the code, even by process of harmonious construction. Therefore, it cannot be said that RARA is a unique legislation that would supersede the code in the event of a disagreement. So that's why whatever the petitioners they are filed is whatever their arguments are there, that arguments are not valid. So, therefore, it cannot be said that RERA is a unique legislation that would supersede the court in the event of a disagreement. Since the initial appearance of the code, section 58F has included allotted flats, apartment, residuary provisions. This legal position made clear by the explanation and dealing function of the introduction of the amendment. So, based on all these facts, it is justifiable and do the justice to the home buyers. And all these things are taken into consideration. And in the public interest domain only, the Honorable Supreme Court of India, they have included the home buyers also can revoke the particular CIRP under section 7, or they can also participate in the COC meeting. So this is one of the important judgment. But the judgment everybody knows about but how the points are to be discussed from the petitioner point of view, from the respondent point of view, from the constitutional validity, and what are the public demand and the law committee recommendations, insolvency law committee recommendations, and all these things are to be taken into consideration to protect the public, particularly for wrong acts of the builders, the promoters of the real estate, who are cheating, who are not giving the flats in time, and delay. All these things are inconvenience to the public. And at the time of the agreement, they are giving one agreement. That agreement they are not fulfilling. Once it is agreement is there as per the Indian Contract Act, then they have to fulfill the agreement. Once it is not fulfilled, then the particular the person who is facing the problem, he can approach the court. So one of the court, particularly for the corporates, is none other than the NCLT. They can approach the NCLT also. And here also, RERA is there. RERA is not an exclusive for the resolution process of the particular the home buyers. They are having a number of other issues also. One of the issue is this one. And the exclusive one is the IBC. And even the consumer firms are there. Consumer firms also they can go. They can approach the RERA also. And they can approach under IBC also. Today, on account of this amendment, now to some extent, the home buyers are happy. And it may not be happiness to the builders, but their hard-earned money to be safeguarded. That is the judgment. That is a justice to be given by to the home buyers, by the Honorable Supreme Court. Analysis of the pioneer. What is the analysis? The Supreme Court debated whether a house purchase might be considered as a financial creditor under Section 5, first issue. Second one is time value of the money. It is important to raise the financial creditor is a person who is own money, and that money has to be idea of the time value. This is also fulfilled, time value, because the timely delivery of the good is not happened means the time value will come into the picture. To put another way, describe the situation which a lender give money to the borrowers who use it eventually pay back the borrowed amount or its equivalent with the interest only. Examining the sections of the insolvency, they have taken into account of the sections of the insolvency law committee also report. Another aspect also this one. and widespread problem of housing project completion delays are also happened, which negatively impacts on the allottees and home buyers was brought into light. This also they have taken into consideration, and the purchases of the real estate make a substantial contribution. That is the main important. Financial creditors amount is a meager one. Operational creditors amount is a meager one when compared to the home buyers. Funding to the project is much more than financial creditor and operational creditor or the class of creditors. And once this is included, then attention will be paid. To some extent, misappropriation will be controlled. And it is a boon to the investors, particularly foreign direct investment to the country, because the infrastructure, particularly real estate sector, is booming, booming, booming. Because once the real estate sector is they contributed a lot to the country, because the derived demand for the steel industry or cement industry or other industries are also parallelly developed. Not only that, beyond all these things, the migrant labor or the workers, they are providing the bread and butter through the real estate sector. As a result, there is a strict necessity defining home buyer's position as a financial creditor. With this clarification, authority to start CARP following the Section 7, this would be guarantees a legitimate position of the commission. Actually, this is a legitimate the position given. Otherwise, once they are contributed, they are neglected, they are not part of the committee of creditors. That is not justifiable. Regarding the second matter, the petition of the Pioneer Urban Land Infrastructure argued that a section so construed the following doctrine of Nictorius Solis and the postulates the statutes of definition of imprecise or unclear or ought to be considered in the light of the phrases the surrounding. So that's a suggestion the financial creditor should refer only the loans money, whether they are not included in the interest rate to be returned with money. Actually, here commercial the agreement and the agreement is also with the interest clause. Once interest clause is there, time value of the money will come into the picture. All are they are fulfilled in this case. The Supreme Court, however, disapproved this view. It is claimed that a residual clause of catch-all, and therefore any amount, any transaction, it is not protected. Another paragraph would be deemed as a financial shows or the commercial borrowing. It indicates the payment paid or flat amount purchases real estate developers completion of the projects are going to be considered as borrowings. The third point is in this case, particularly the yield to real estate regulations, particularly the RARA Act is a supplementary one, not primarily for resolve this home buyers problems. The underlying assumption of this argument is IBC is broad legislation that deals with the insolvency concerns, where RARA is a specialist act focused on the regulation of the real estate development project. The Supreme Court disagreed with this claim. It emphasizes the position of two main justifications. First one is the RARA Section 88 makes the Act's provision supplementary, do not supplant this one. And this suggests in addition to the remedies of IBC and RARA. So finally, they have made this two justification. Second one is observed that non-abstent of the provisions of IBC adopted December and registered earlier in 2016. So 2018 only, they have given a due weightage under section 58F came into the picture, and they have included the home buyers also under financial creditor. Then the Article 14 of Indian Constitution Act also they have fulfilled. In this case, the equal rights to be treated unequally or unequal parties are equally, and there is no obvious reason distinguished between these two. The Supreme Court, however, disagreed with this claim and offered several arguments in favor of the instance. And it is clear that real estate developers and operational creators differed fundamentally from one another. So this is the brief once, and this is a good sign, particularly for the real estate particular home buyers, and the court also given the this other cases also they have required. So in the conclusion, what conclusion is, according to Supreme Court, neither Article 14, 1G in combination with Article 96 nor 300A, the Indian are violated by the amendment of the. They finally concluded the IBC insertion of the home buyers in committee of creditors or treated as a financial creditor is not a violation of the particular Article 14 or 191G or Article 300A of the Indian Constitution. And the insolvency and bankruptcy supersede the RERA in the event of disagreement. And the two courts are intended coexist. The Consumer Protection Act, RERA, and IBC are among the concurrent remedies and apportionment rather than bring out the major change. And fifth, the Section 5(8)(f) shortly clarify the current legal situation. This is in brief what I told. But actually, these two are related to the real estate sector only, the two cases. But while including the home buyers in the financial creditors the definition or including the COC regulation, then some rationale is there, some reason is there, some justification is there, some public interest is there, and these people should not suffer. Once they suffer, then economy, lot of problems will face. Real estate sector will not grow. Once people are not trusted the real estate sector, how the real estate sector will they increase. So all these things are taken into consideration, and they have not violated the constitutional provisions or whatever it is there. And that's why this is a best interest of the public interest. They have included the home buyers in the committee of creditors. Either JIL or JAL, particularly in that case also, always the builders are trying to cheat the home buyers. And these two cases, one is inclusion of this one, and the second one is once the CIRP is over, the Supreme Court of India is having the powers to revive the CIRP, and that type of provisions are also there. But being a IRP or RP, whenever we are handling the CIRP process of the real estate, and we have to go through the RERA Act or the particular the company, whatever the agreements are there with the home buyers, and whether they are following the RERA compliance or not, and why the project was delayed, why the particularly in most of the real estate projects, the PUF transaction, preferential, undervalue, or extortionate or fraudulent transactions, n number of cases are there. And if you verify that a particular accounts, definitely you will come across. Otherwise, why the project was delayed? Why the liquidity problem is happened? Why the timely is the cases are not? Why the flats are not they hand over to the particular buyers in time? Because some problem is there. The problem is the funds diversion. So with this, I am concluding. Thank you very much for giving an opportunity to discuss about these two cases. Thank you very much, and thank you to all.
Thank you. Thank you, sir.
Thank you.